This commission meeting to order. Please rise and pledge the flag. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Ms. Taylor, would you call the roll, please?
Commissioner Lyons?
Here.
Vice Mayor Stanley?
Here.
Commissioner White?
Here.
Commissioner Orthwein? Here. Mayor Morgan?
Here.
Let the record show that Town Manager Thresher and Town Attorney John Randolph and Police Chief Edward Allen and our staff attorney Trey Nazaro are all present.
Thank you very much. We've had the minutes from our last meeting, December 9th, 2006, provided to us. Are there any corrections, changes, comments? If not, it's a
I don't know
motion.
if,
I'm sorry.
I don't know if it's a typo or they say Edward Nazaro, and I know it's Trey, but maybe the name is Edward.
That's right.
Okay.
Edward stands. Any others? If not, is there a motion to?
Actually, I had one other comment. On page 3, at the bottom, last paragraph, where it starts Chief Allen, on the last line it says, "To those who responded here," I'm not sure if that's the right word, responded here? Maybe I'm misreading it. Is that clear to you? That,
To those who responded.
We're
I
on
don't know.
here.
I got the gist of what he's saying.
Yeah.
Bottom of page 3, last paragraph.
You're questioning responded.
yeah.
Yeah.
The word responded.
Well,
If it's clear, the others, it's fine. Let's move
I
on.
think I know what he's saying.
Okay, good, fine.
I'll move to approve the minutes.
Thank you.
Is there a second?
Second.
Ms. Taylor?
Commissioner Lyons?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwein?
Yes.
Mayor Morgan?
Yes. All right, we have a couple additions to the agenda today. Resolution 17-01. Rita, we're going to move that to items for commission action. We'll make that number 2. And we're also going to have a report from Special Counsel Sweet Apple to the commission, which we will put at item 8, which means 8, public hearing will then be 9. 9 will be 10, 10 will be 11, etc. Okay. Next meeting, February 10th, 9 a.m. for all who wish to attend. And we have proclamations today. Mayor's proclamation for election. Ms. Taylor?
Well, all I've got to do is find it.
You may have mine.
I guess I'm gonna need it. Mayor's proclamation for election. Whereas the town charter of the town of Gulfstream, Florida requires that a town election be held on the second Tuesday in March in a year in which a vacancy or vacancies are occasioned by expiration or early termination of the terms of office of commissioners, and whereas the terms of the town commission members are expiring in March 2017, now therefore Scott Morgan, Mayor, does hereby proclaim the following. An election will be held on Tuesday, March the 14th, 2017, for the purpose of electing 5 town commissioners who shall hold office for a term of 3 years beginning on Friday, March the 17th, 2017 at noon. Number 2, the election shall be held in the Town Hall of the Town of Gulfstream, Florida, located at 100 C Road in Gulfstream, and the polling place shall be open between the hours of 7 a.m. and 7 p.m. Eastern Daylight Savings Time. Only qualified registered voters of the Town of Gulfstream shall be allowed to vote in this selection. Number 4, any person who desires to have his or her name placed on the official ballot shall file with the town clerk beginning at noon on January the 31st, 2017, and no later than noon on February 14th, 2017, a petition signed by at least 4 qualified electors of the town of Gulfstream requesting such person to become a candidate for such office. Number 5, a copy of this proclamation shall be posted on the town bulletin board at least 30 days prior to the day of election. In witness whereof I have set my hand and caused the seal of the town of Gulfstream, Florida to be affixed this 13th day of January 2017, and it will be signed by Scott W. Morgan, Mayor.
Thank you. Just to reiterate, candidates for town commission filing dates from noon January 31st to noon of February 14th this year. Let's move on to public comment. Anybody wish to speak? Okay.
This will be very brief. I don't even have to take an oath on this one. I just want to thank you all for being so kind and thoughtful. This has been a long trip for me. 9 months in a couple of weeks, and I'm supposed to get better in 9 to 12 months, so this is kind of a little bit early, but all of you have been so kind and so thoughtful, and I am so very, very, very thankful. We got a great town here, an awful lot of awful nice people, and I really appreciate it.
Thank you, Bob. This town is great in no small part to your input, your help, everything you've done over the years, Bob. So, credit goes to you as much as it would go to anyone else in this town. Anyone else wish to speak?
I'm Mary Ronnie. I'm Nancy Tuohy's daughter. And many of you know that I lost my mom in October. And I'm here to thank everybody. My family is now charged with selling her property. And she was there for almost 20 years. My 5 daughters grew up swimming in the pool and doing somersaults down the hill. And she loved this town. And my family's going to miss it, and I just want to thank everybody because everybody has been so kind to my family and so supportive of my family and my mom. And I know she'd want me to be here to say thank you.
Thank you. Your mom was a great woman, stalwart, involved in this town, my neighbor, just a wonderful woman. She'll be sorely missed. Worked with her on a number of things. And, she's just a warm and intelligent, dynamic, vibrant woman. She will be missed. What's your name?
Mayor, I'm Chet Snavely, president of PAS Homeowners Association. We're very concerned about the pending Gunther Volvo development in Delray Beach on Federal Highway. In our development, Quinn Miklos, architect, backs up to this property, and Quinn is kind of heading our investigative efforts into what the final development plans may be with Delray Beach. With that said, the 23rd of this month, we are having an HOA meeting. Starts at 7 o'clock. We invite all the commissioners to attend. Actually, 7:30, the representatives from Gunther Volvo will be there to discuss with us their plans and get our input. Quinn sent a letter that Mr. Thrasher and Mayor Morgan were both copied on, but you have a copy. I have 4 extra copies if folks would like to read that possibly before the meeting if you would like to attend. I think this is very important. Municipal planning, good municipal planning is at stake here, and we need a good relationship between the city of Delray and the town of Gulfstream. And with that in mind, I have these. Am I allowed to pass these out? I don't know the protocol.
I'll preferably put it on the table,
All right.
out in the vestibule, so people can pick it up there.
Okay, thank you.
Thanks. Anyone else wish to speak?
Mr. Mayor, Commissioners, wasn't planning on speaking today, but I'd just like to say it is very good to see Commissioner Ganger here, and I hope that he has a speedy, continued recovery. It's great that he's overcome his recent difficulty. Also, because Mr. Sweetapple is here, I assume that what he's going to present to the Commission is an update on the status of all these lawsuits, and I just wanted to say that we had a hearing that just 2 days ago in which the judge found for the town. I disagree with the ruling, so do my attorneys, and will of course appeal that. And my attorneys seem to think that it's very right for going all the way to the Supreme Court because of the issues raised. What I want to bring to your attention though is what that case was about was I asked for a record. Ms. Kelly Avery the very next day sent it over to the town attorney because it was a record of theirs. And the town attorney took over 50 days to respond, and that's where the problem lied. It wasn't the town's fault, it was the town attorney's fault. Now, the town, on this particular complaint, well, all the complaints have spent unbelievable amounts of money, so have I. But given that this is going to be appealed and perhaps even go all the way up to the top, do you really want to continue to spend money like this on the town for records that are just a single page, an email from the town attorney to a resident? I couldn't get that. All I got in 50 days was a request for a clarification. It just seems like this is a great waste of public money, and I wish you'd have your executive session or whatever and discuss these things and see if you really want to keep spending money like this. It just seems a waste of taxpayer money. Thank you.
Thank you for those comments. Anyone else wish to speak? Yes, sir. Graziano?
Good morning, Tony Graziano at 3259 Polo Drive. It seems that we're going to have a report on the undergrounding this morning, so I would hope that we could have one question addressed that I have gotten from a number of my neighbors. As I'm sure the Commission knows, that there is a utility alley that runs behind the houses on the west side of Gulfstream Road and the east side of Polo. For what, 50, 75 years, all the utility lines have run down that alley, and whatever transformers or other equipment FP&L needs are in that alley. Somehow, in connection with the undergrounding, FP&L has decided that that alley can no longer be accessed, and we're going to have transformers sitting in the middle of people's lawns on Polo Drive. And I'd really like to have our gentleman address why that is necessary. In 50 years it's been able to be accessed through the utility alley. Why now all of a sudden do the neighbors on Polo have to have transformers in the middle of their yards? Thank you.
Thank you. Anyone else wish to speak? If not, let's move on to the next item, which is Attorney Sweetapple's report to the Commission.
Good morning. As some of you may know, starting in December, 3 cases that were brought by Mr. O'Hare were tried before the Honorable Thomas Barkville. And prior to the holidays, the court ruled in favor of the town on 2 of those cases, and finding our right to go in and seek attorney's fees based on the conduct of that filing, which we will be doing. The 3rd case, which is a case of first impression in the state of Florida and maybe in the United States, concerned the issue of whether or not our attempt to plead and to prove that the lawsuit filed by the O'Boyle Law Firm on behalf of Mr. O'Hare was in fact filed in bad faith and for the purpose of generating litigation solely to try to obtain money from this town. And I'm, first of all, very grateful to Ms. O'Connor and the Jones Foster law firm, which has worked tirelessly on this defense of these dozens of cases that have been brought, as well as Mr. Nazzaro, who has thankfully come on board. Ms. O'Connor and Mr. Nazzaro prepared an excellent legal brief that tracked the whole history of public records litigation. They had some help from the standpoint that the entire Florida Bar appears to be interested in the issue, and you were featured in a Bar Review article published by the Florida Bar in November. And there seems to be a national awareness that Florida and now other jurisdictions that have liberal public records rights are in fact ripe and becoming the source of abuse for lawyers and individuals to just generate litigation to obtain attorney's fees. And there's a number of reasons why that that market, if you'll let me be facetious, exists. One is because typically the right to obtain a public record is an absolute right. It's a right often used by prisoners who need records. The law says a stalker who wants to get records regarding investigations of his stalking. Anyone has a right in our society to get records timely from government and government's employees. So there's an absolute right, and the law says that the motivation of the individual, not only his character, but the motivation of the individual is totally irrelevant. You just have to produce the records. So that invites abuse just with regard to that. Then when you recognize that the attorney's fee clause is one way, only if you win as a plaintiff, you get fees. If you lose, nobody gets fees. So it's an interesting casino. You can't lose. As a lawyer, you can just bring as many of these as you want, and whichever ones you win. And there's no risk. So the law is loaded in favor of the prospective plaintiff or citizen, and the rewards are there, and thus you have what we see having emerged, and Gulfstream has become basically the poster child for this conduct, not only in Florida but throughout the nation, because what you can do, obviously, is you can take a small municipality and just abuse public records litigation to the point where the municipality has to capitulate to whatever demand you have. And what occurred in the third case that we tried, which actually, I don't know how Mr. O'Hare could have forgotten this, but it actually concluded yesterday with Judge Barkdale issuing his ruling from the bench, which is unusual, but he issued a detailed ruling from the bench at the conclusion of the case. The reason the case was a case of first impression is because the defense that a municipality or anyone who's obligated to provide records has is that they acted in good faith. So maybe there was a delay. In this case, it was a 50-day delay. Maybe there was a delay, but we acted in good faith. And you look at just the general circumstances on a case-by-case basis to see why in the world 50 days transpired. Well, in this case, contrary to Mr. O'Hare's statement that he made at this very podium moments ago, the request, which was one of 10 requests he served on May 14, 2014, which those 10 requests resulted in 7 lawsuits. that were farmed as a result of that day's activities. That request was transmitted to Kelly Avery, who I also want to commend because she has left her employment on repeated occasions to testify at depositions and to testify at trials, and she's been forthright, and it was clear she testified she was scared of being sued as a result of the conduct that was occurring in this town, and the judge noted that, as you'll hear. But Kelly was very forthright and explained exactly what was going on here in this town. So basically, you have a situation where Mr. O'Hare, in his request, which the court found was a gotcha request, basically asked for over 20 items of types of documents, diagrams, memos, letters, emails, everything you could possibly imagine to describe a writing. And he asked that the town provide all of these types of records of anything that was sent or received or concerned Mr. O'Boyle that the law firm had, which of course would require, unless you're going to be caught not giving something, going to every lawyer and employee at the Jones Foster firm to determine what the estimate is to even comply with that. Does that mean pleading sent to your lawyer, Mr. O'Boyle's lawyer? Does that mean memos between the lawyers? Well, this could be a huge request, or it could be just something that was actually sent to Mr. O'Boyle by the law firm. So ultimately, a clarification was requested, and it was stated in the letter that we assume you just want what was sent to Mr. O'Boyle or from Mr. O'Boyle law firm. In that case, it's $22. Mr. O'Hare never responded, never asked to see any of the documents, never offered to pay the money. And this was a part of a typical conduct that had been occurring at that time, where requests were made, estimates were then prepared by the town, and then no further contact. And of course, the law is that you can do that to your heart's content. I can come in here and ask you to give me an estimate of what it costs to give me every public record you have, and you have to go give me the estimate, and I can show as I please. And if I decide I don't want those, I can just have you do it again tomorrow. That is the law. So what we have been advocating since I got involved in litigation is that while the law is infused with the concept of good faith, and that you do look to the town's conduct to see if they acted in good faith in light of all of the circumstances when there is a delay, that this is a court of equity when you start talking about the town's good faith. We need to start changing the focus to the plaintiff's good faith. Is the plaintiff acting in good faith? And throughout the litigation that's been advocated by lawyers for the requestors, that the law's clear, motivation doesn't matter. You can't look at the plaintiff's motivation. It's irrelevant. This is clearly established by law. But as a professor of mine at the University of Florida in 1977 said, and I didn't really understand it at the time, he said, you change the facts and you change the law. He said it in a squirrely Wisconsin accent, which I won't try to imitate, but I was like, how did the facts change the law? Well, when courts realize that their law is being abused and facts change, courts rule to meet the changes in facts. And my theory here was the law needs to change. We need to assert in every opportunity we can that the conduct of this individual, this requestor, these lawyers is in bad faith. It is being done to generate litigation. Unfortunately, our co-plaintiff in the RICO case, the Wantman Group, obtained an appellate decision within the last year where the 4th District Court of Appeals said, wait a minute, these laws should not be used to generate litigation. That's not what this is about. So they opened the door in our jurisdiction to start looking at what's going on. So the first case where this affirmative defense of bad faith was concluded yesterday. And if you'll bear with me, I'm going to read to you a lengthy ruling by Judge Barkle that will concern not only this case, but of course the entire enterprise that's occurring by anyone who is engaging in these activities. And we maintain to become res judicata with regard to all the other cases Mr. O'Hare has filed, not only on this day, but as to his other cases. And the entire log, one of the smartest things Joan Foster did and Mr. Mazzaro worked on from the very beginning was to log these, so I could show the court that 2 weeks before this request to Jones Foster, there were 41 requests for every bill and all the backup on the bills with Jones Foster, which would require redaction of all the lawyer-client material that's contained therein, where the town's represented by Jones Foster in litigation with Mr. O'Boyle, and Mr. O'Hare is asking for all the lawyer's work. So that was pending 2 weeks before this request that was subject. And there were 234 other requests, mostly by Mr. O'Boyle, using different aliases that were filed during this 50-day delay period. 234 requests. So before the request is filed for 2 weeks, 41 backups on all your bills. Now give me anything your lawyers are doing, basically with regard to Mr. O'Boyle. And the minute you have the request, by the way, here's 234 more requests that Ms. Avery and your staff can deal with. But I'm entitled to have this now under the law. So here's what the judge had to say about that. And we'll be preparing final judgments and motions for fees as a result of this ruling. The court, and this is in the case of Christopher O'Hare versus the town of Gulfstream, and this was issued from the bench at approximately 11 o'clock yesterday morning. The court, this is an important case. We all thought it was going to take a half day. It's taken well over 3 times that, which is fine because it's an important case. It's an important issue. It's a very important public policy. Public records in the state of Florida and the legislative intent is clear. Legitimate requests for public records are something that is a public policy, and people of the state of Florida who are making legitimate requests for public records are absolutely entitled to a prompt and full response. This is a case, as both sides have said, of first impression as it relates to one of the 2 issues that were put before the court here. There has never been an actual trial of the affirmative defense of bad faith. The federal courts, Judge Mara and his affirmants, have referred to the dismissal of the RICO actions, which I took judicial notice of, and that affirmance said that it was to the state trial courts to look at this, not to be brought as an action initially in federal court. So it has ended up here for the first time, and we've been able to actually take evidence and look into the issue and look at the case law and hear the excellent arguments on both sides. Of the 2 very important and separate and distinct issues, of course, that were tried was number 1, the claim by the plaintiff that there was an unreasonable denial of the production of appropriately requested public records. There's no hard and fast rule when you look at the cases as to what time frame is or is not reasonable or unreasonable. It is not set forth in the statute. It is controlled by the circumstances of each case and every request. So we have to look at the range of cases that say that anything from as little as maybe 10 days to as long as more than the time in this case is reasonable or unreasonable, and everything in between. So I need to look at the specific facts and circumstances that took place and was presented by the testimony in this courtroom as to whether there was a reasonable response time. That was issue 1. Issue 2 is the affirmative defense raised by the defendant that this request and the procedure and method and conduct of making this request constituted bad faith and prevents the requirement of a timely response. So let me deal with those separately and distinctly. The first one is the issue whether the delay in this case was reasonable. I find that given the entirety of the surrounding circumstances at the time of the request and the response thereto, that the delay was reasonable. There had been a deluge of requests both by this plaintiff and numerous other parties seeking hundreds and hundreds of public requests, oftentimes in large bursts that were sent or that were compiled over a period of days or weeks and sent in burst batches on a Sunday night or a Monday morning so that the requests were received first thing when someone would walk into the office on Monday morning. The logs are in the record. There are literally hundreds and hundreds of requests. But it wasn't just the requests that I had to look at, what was happening in the small town of 900 residents. There were many other things going on at the same time that occupied the clerk's office. There was the issue of parking regulations. There was testimony that was not only going on within the clerk's office, but it was going on in Jones Foster too, because they were involved in the drafting of those. There was the issue of signage on one of the candidates' vehicles. There was an issue of the fact that there were numerous pending lawsuits that were being handled by both the village or the defendant and its counsel at Jones Foster. That is in the record. And in addition to that, there was an election to conduct in this village. So the election was also taking up the time. Ms. Avery in her testimony said that she was in constant contact with Jones and Foster on any number of issues dealing with the regulations and the records requests. And it's clear that some of the requests in the log that were easy to respond to, that were calling for a specific individual document, that were easily identified and were not voluminous, these showed that the village or that the defendant acted in good faith and responded to them as quickly as they could. In this case, the request was voluminous and was not clearly worded. Whether that was intentionally done or as an attempt to thwart the town's ability to respond to it, or whether it was mere inartful drafting, the court is unable to determine, but it requested numerous documents, some of which it was unclear as to what actually was being requested. Therefore, the pattern of the village, as shown by the log, was to respond in good faith if they had the ability to do so where it was limited, a limited request that was easily identified, and they were able to deal with it in good faith as they did. I find this request and the surrounding circumstances made it virtually, I'm not going to say impossible, but I'm going to find that there was a good faith effort to respond, and the plaintiff's complaint fails on that ground. The second issue is the issue of the affirmative defense of bad faith. I find it is clear from the testimony of Mr. O'Hare that he was angry with his past dealings with the town, and that anger motivated his conduct. Now, I'm not basing any ruling I make today whatsoever on motivation. Motivation has no bearing on whether a request is appropriate or not appropriate. But that is something the appellate court needs to be aware of as to what may have prompted the conduct that arose to the level of bad faith. And I'm focusing on the conduct only and not the motivation. The conduct in this case was clearly an attempt to inappropriately generate litigation and inappropriately generate attorney's fees based on that. And that has been specifically disavowed by the 4th District Court of Appeal in the case of Citizens Awareness versus Wanton Group, found at 195 Southern 3rd, 396. I'm going to specifically quote from Citizens, quote, "Public records law should not be applied in a way that encourages the manufacture of public records requests designed to obtain no response for the purpose of generating attorney's fees," end of quote. It is clear from the testimony that in this case, there were numerous records requests that were compiled over days and weeks and then blasted in large amounts. And many of the previous requests prior to this one, there had been no pickup of the documents requested. There had been no payments of the estimates for prior documents. And in this case, there was absolutely no follow-up to the request prior to the initiation of litigation, which leads directly to the issues raised by the 4th District Court of Appeal in the Citizens Awareness case. In this case, not only did the plaintiff make requests in his own name, numerous requests, he used fictitious names, which is okay, but he has also used the names of parties that actually existed but claimed he had authority to use. These were included in the logs and identified by the plaintiffs and shows the numerosity of the request. The request itself was also inartfully drafted. It was appropriate to, as the city did, take time to review it and compile a response inquiring exactly what was drafted. Given the history of this case, it appears that the inartful drafting may have been intentional to cause the very sort of gotcha conduct that this case entails. The conduct was clearly intended to generate litigation and fees, and additionally, it was clearly intended to harass and intimidate the employees of the town. And to that extent, the plaintiff was successful. It was clear that he had intimidated and scared Miss Avery. Through the eye of the court, the trial court had the opportunity to view the testimony of the witnesses in this case, and it is clear that Ms. Avery was in fear of the type of questions and inquiries made by this plaintiff. And after watching him on the stand, it was clear that that was one of the intents of his methodology. It was clearly in bad faith, a bad faith attempt and gotcha request, and an attempt to generate litigation and fees, which is inappropriate under the citizen's case. This court, nor any other court, should tolerate such wholly inappropriate action under the statute. It subverts the intent of the statute. It subverts the public policy of the state of Florida because it prevents public employees from being able to respond to legitimate public records requests. Therefore, I find that the plaintiff shall take nothing by this action. I enter judgment in favor of the defense and will reserve jurisdiction to entertain any request for fees or costs by the defense in this case, including any fees that are available under the court's inherent authority for bad faith litigation. I'm going to direct the counsel for the plaintiff, or excuse me, counsel for the defense, prepare a detailed order in conformity with my ruling, cited to the record as I have and to the case law. Run a copy by Ms. James for her review, If you cannot agree on the form, please send me the suggested changes and I'll look at the two. And if I have to have an additional ruling conference, I will. If not, I'll make changes. Any questions from either side? Ms. James, no, Your Honor. The court, okay. Mr. Sweetapple, no, sir. The court, okay. That concludes the trial of this matter. I'll look forward to reading the 4th District Court of Appeals opinion after it comes out in this case. Hopefully, it will give all of us some guidance and clarity as to the appropriate application of Section 119, the public policy which it was intended to, the legislature intended it to be used for. That concludes the trial of this matter.
Thank you, Mr. Sweetapple, and the town thanks you and Ms. O'Connor and Mr. Nazaro for all your efforts, particularly yours. It's been almost 3 years we've been working on this, and that is certainly a legal vindication of your efforts in defending this town. Let's move on to the public hearing. We have an application for development approval. Any ex parte communications? If not,
No.
let's move. This is an application submitted by Mr. Bodker, landscape architect, for property 3244 North Ocean Boulevard.
Good morning. My name is Dave Bodker, 601 North Congress Avenue, Delray Beach, Florida. This morning I am representing Bobby Morrell and Christine Muir, and their property is located at 3244 North Ocean Boulevard. With me this morning is David Frank of Precision Drafting and Design. We are proposing the removal of an existing swimming pool and pool deck on the south side of this existing residence. The existing pool and deck occurs approximately here on this property, and the desire is to create a new swimming pool, a new pool deck, in addition to a hard roofed lanai that will occur, if you can see here, the darker shaded in area on this plan. The planting plan is pretty simple. It only includes the addition of 5 12-foot areca palms right in this area to additionally screen the new lanai that will be built. We also have colored in here existing coconut palms, which are the more lighter shade of green, and we are proposing to relocate foxtail palms between the existing coconut palms. So they're a little bit darker chartreuse color here, 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 and there. Additionally, along the south property line, there's an existing 6-foot ficus hedge that runs the whole length from here to here. And based on the existing landscape and what we are proposing, I don't think there's any additional consequence of views from the neighbor to the south, who would be the only one that would be affected by this construction. Just as a side note, the neighbors to the south have just recently completed a 2-story addition to their residence, which occurred in here. And they did add some Christmas palms on their side of the property to screen what they constructed there. I have some photographs. I don't know if they were included in your package. If not, I can pass out the ones that I have.
We have them.
If you have any further questions, I'll be glad to answer them, or David Frank is here to answer anything regarding the architecture.
Now I have one question. Yes, sir. You're installing a chimney, an outdoor fireplace, I know what it is, correct?
Yeah, it's on the south side of the new lanai. It's actually in line with the south side of the house right here. I don't know if you can see it. I'll bring this up to you if you can't, but it occurs right here.
And how high will that be?
Dave?
It's going to be 2 feet over the height of the existing roof.
So what I'm really curious about is the landscaping. Will that block most of that chimney?
The height is. Yeah, I don't know if you can see this, I'll bring it up there, but the chimney occurs right in here, so you can see that these new areca palms that we're placing right in this area here, you can barely see that chimney. It's right behind this coconut palm as a result.
Well, the rendering suggests you don't see it.
Yeah, for the most part. yeah.
Ultimately, that's going to be
Yeah.
the outcome.
That's correct.
Thank you.
Any other questions?
Are the areca palms all the way down the whole line, or from that picture, it looked like they were just where the chimney is?
Yeah, we're just adding them right in this area here. Here's the addition, the chimney is right there. So the new arekas are, but to answer your question, no, they do not extend the whole way. They pick up again here, there's some existing arekas in this point right here, but no, they don't extend in that area. This is a one-story home. The lanai is also a one-story structure. It's the same materials as the existing home, the same roof material. It's just an open air lanai. There'll be one column at this corner to support the roof.
I guess my question was based on the fact that with the ficus still being there, it will be difficult to treat it for whitefly with the areca,
Right.
growing there.
Yeah.
That's a lot of density.
That hedge is in pretty good condition. I don't know if the neighbors treat it. It's kind of a shared hedge on both properties.
Any other questions? If not, are there any motions to entertain?
Make a motion to recommend approval of demolition permit to remove the existing pool and prepare the structure for addition. This is at 3244 North Ocean Boulevard.
I'll second that.
Ms. Taylor?
Commissioner Lyons?
Yes?
Commissioner Stanley?
Yes.
Commissioner White?
Yes?
Commissioner Orthwein?
Yes.
Mayor Morgan?
Yes?
Second motion is motion to recommend approval of special exception to permit the addition of a covered patio, also referred to as the lanai, on the south side of an existing non-conforming Bermuda-style one-story single-family dwelling, the north side of which encroaches approximately 5.24 feet into the north side setback.
I'll second that.
Ms. Taylor?
Commissioner Lyons?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes?
Commissioner Orthwein?
Yes.
Mayor Morgan?
Yes.
The third motion for this application is a motion to recommend approval of the level 3 architectural site plan based on the finding of the proposed construction of a new swimming pool and jacuzzi, the construction of a 6-foot high wall to conceal the air conditioning and generator units, and the addition of 482.5 square feet covered patio with outdoor fireplace to the existing Bermuda-style one-story single-family dwelling, which includes adjustment of, in addition to the landscaping, meet the minimum intended design manual and the applicable review standards for the following condition. Condition number 1, a 4-foot high photocarpus hedge material shall be placed in front of the neighbors or street side of the existing chain link fencing.
Is there a second?
I'll second it.
Ms. Taylor?
Commissioner Lyons?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes?
Commissioner Orthwein?
Yes.
Mayor Morgan?
Yes. Thank you very much.
Thank you very much.
Let's move on to reports, undergrounding report. Mr. Brown.
Last time I was here, Bob Manger was here.
Oh, jeez.
And it's great to see that Bob is still here. Still Bob is part of this. Florida Power & Light has been told by the FDOT that they can't remove the existing overhead poles on A1A in phase 1 of the project until the new street lighting is installed. So FPL is right at this point waiting for FDOT to approve the permit to install those lights. And as they install those lights, they can take the old poles down. The phase 2 work that we're currently engaged in, the final completion date, that according to the contract with the contractor for the installation of the town's work, is June the 15th. The contractor has installed conduits along Polo Drive and on the side streets west of Polo Drive, including Old School and all the way down to Golfview, and has installed the conduits along Golfview. This week, the contractor added a second crew, and the contractor plans on adding a third crew, and they'll be significantly increasing their efforts here. The contractor has approached me requesting approval to work on Saturdays. I'm not sure as to how the town would process that request, whether Bill Thrasher has the authority to act on that request, or whether the commission would be required to approve that request.
Mr. Randolph, is it something for the town manager, or must we consider it?
I don't know the answer to that. I've not had that question come up before. Maybe Bill has.
For the record, it's my recollection that during our pre-construction meeting, this question was asked, and I gave approval for that process.
And yeah, and approval was subject to the conditions and the request and those kind of things. I see no reason not to approve the request. I know that we did so for how.
It's done in phase one?
Right.
Okay.
You can certainly ratify that if there's any, if anybody raises any question as to whether you would allow it.
Well, I think we probably should, since there is some uncertainty about it. So the request, as was done in phase one, for phase two is to allow the contractor to work on Saturdays, or normal business hours.
Well, can you give us, Danny, for the record, a quick snapshot of, because it's high season, of course, until May 1, a quick snapshot of the activities, just for everybody. We know them, but just for the record, before we make a decision on it. Or ratify it.
It's primarily to continue the work they've been doing on Polo to install the duct system. If there's a concern as to various types of construction that you might have, you could voice those, but they will start placing transformers, pulling cable in the pipe on the south end as other crews are continuing to install the pipe going forward to the north end. So it's going to basically be more of what we've seen already. The pipe installation is probably the most intense part of the construction. You have equipment there that are doing the directional drilling. You have reels of cable and things like that. So you have other vehicles at the other end of the line that once the rods get to the other point, they attach these cable reels of pipe on and they pull them back through the ground. So that is typically the most intense construction phase.
So there is noise associated with the work that they'll be conducting?
Yeah, and probably the biggest noise is probably from the pumps that pump the driller's mud.
Direction board.
What, I mean, it just seems to me then that on a Saturday, they should not be starting at 8 in the morning, but rather later.
And the other thing you could consider is that they maybe limit their work to cable pulling and equipment placement, which would mean they wouldn't be drilling on Saturday. That's another option you have.
Yeah, I think that'd be an idea,
Okay.
you know, because it's a very noisy, it is a very noisy process.
Yeah, I know it's very disruptive on Saturday mid-season. I don't like it at all. So
I hate to have that all through February, March. Is that what you're saying? It's not going to end for a while.
They will probably work as hard as they can to complete the job as soon as they can, so that gives them another day to work. If you have your crews mobilized on a site and everybody's geared to do the site,
right,
then working as intently as you can while you're there is the best thing for the contractor.
if they can modify their work efforts so that on Saturday they're not doing heavy equipment, pumps, rather they're pulling lines and doing less noisy work, I think that should be.
They haven't dropped any of the transformers in yet, have they? I haven't taken a ride.
No.
Right around yet.
We have a request to do some landscape removal on about 6 locations where we were into the typically ficus hedge or stuff like that. So they're getting ready to start setting transformer pads and putting cable and equipment in.
So this is possible to work on Saturday without the noise?
We can have approved them working on Saturday with exclusion of no drilling operations. In Palm Beach, we're working there, the off-season period in the summer is when they're allowed to do the drilling.
Right.
And they have to stop it when the season starts.
No drilling and no pump operation, correct?
How does this impact the June 15 completion date? Your suggestion of working on Saturdays, if it's not granted, it's not going to be completed by June 15th?
No, this doesn't affect the schedule.
Meaning it'll get done earlier then?
The contractor works on various types of projects. They have contracts with FPL, they work all over the place, they do. We've been doing a lot of submarine cable installations over the West Coast. So they're trying to coordinate their work. So they've got crews that do this kind of work. If they're in this area, can they get those crews completed up so they can move to other projects? But this does not affect the overall completion schedule.
I have one more question. Can you address Mr.
Yeah, we
Yeah,
Well, what
the
is
comments?
Are there more questions regarding Saturday operation? Concerns with the limitations?
I'd like to get it done, but I don't think the drilling is a good thing on Saturdays.
Right, if we approve it, there would be an exclusion
Yeah.
on drilling or pumping.
In Palm Beach, they were going to be doing cable installation and equipment placement during the season.
Okay, no, I don't, as long as they're not drilling and pumping, because it is a very noisy
Right.
process.
Palm Beach wants to send the noise down here. But more seriously, I mean, Palm Beach doesn't want the noise, so the general contractor wants to do it down here. I mean, I understand his business, but.
The plan for Palm Beach is the drilling would be off-season because that's the noisy part. And the cable and the equipment would be during season because that's not such a disruptive process. And that's basically what this authorization would do, would mirror that. It would allow the cable and equipment to be installed on Saturdays, but not the drilling.
What's the best we can do?
Right.
Otherwise, Bill's cell phone will be lighting up about 10:15 first Saturday, or ours, or all the above.
Is that right?
Well, you could also not authorize it, if it's not going to affect the deadline.
That's the answer.
If it's not going to affect the June 15th deadline, why authorize it?
And you may have you could have an option to delay the beginning of that authorization if you wanted to, but you delay it to Easter.
Seems to me they committed to a deadline. There was at least 3 weeks where they weren't doing anything here. I think they brought this on themselves. I don't see why our residents should be disrupted on a Saturday, even without pumping and drilling. I'm against it.
Are there any other issues besides the noise issue? How about traffic patterns or people being able to access driveways?
It would be typically the same thing we're having during the week now.
I'm not here during the day, so I don't know
Yeah,
who's,
it's,
who has a better snapshot who's traversing the neighborhood during the week on, and I haven't heard any comments other than the infamous transformer issue, which is still looming, but, as far as traffic, I mean, there were some streets, I think we had some residents, 3 or 4 meetings ago that were, complaining a little bit about directional boring. Some of that was construction unrelated to the, undergrounding, that was, new home construction, but.
We had one complaint about setting poles that they thought it was the underground crew that kind of does it set poles.
I mean, the residents they want it done. You know, they want minimal disruption on Saturday activities until May 1. But we really have no idea whether it's gonna be done on June 15th or not. And I don't know, where else is this contractor
think that-
mobilizing? I mean, are they here, or where else are they?
They work all over the state.
They're all
They have
over.
contracts with FPL, they work all over the state.
We have penalties in place if they pass the June 15th.
Maybe we should defer this request until the next commission meeting. It gives us a chance to see what it's like when they have this third crew in here and how intense it is. It gives us a better feel for what a Saturday might be like with a full bore complement of
I'm
resources.
sorry,
They're gonna bring a third crew in
during the week.
during the week.
Yeah.
And they already have 2 crews. And so if we give them a month to show us what the traffic is like, what the disruption is like with 3 crews working in the area, then we could review this again next commission meeting and see if we felt that we could tolerate that on Saturday or not. But you really haven't seen the full scope of 3 crews working at the same time.
Powerman crews, you're gonna have the trucks involved and you're gonna have noise, the backup trucks with the beeping. And in this town, the streets are narrow and the homes are close together. It just seems to me that people live here and they come here for the quality of life, and this project has been disruptive enough. That's just my inclination based on what you said. I'm convinced otherwise, but that's kind of the way I'm leaning right now.
So,
We'll take it back to them that we denied at this point.
But right now, we have an authorization per the town manager's preliminary meetings.
That is true.
I think we need to vote on
so we have a motion in the affirmative or in the negative?
it. You can make a motion in the affirmative, or make the motion, and it can be voted on.
Make a motion to allow the underground contractor to work on Saturdays, limited to wire pulling and transformer installation, and no drilling and no running of pumps.
Second.
Who seconded that?
Nobody's-
Tom. Okay, thought I missed it.
Well, if it gets seconded, we can vote on it. If there's no second, it will not be voted upon. And perhaps it doesn't matter, but I think it should have a second, because otherwise we have in place authorization for them to work on Saturdays.
Maybe we need to do it in the negative.
I second.
Just second.
Second.
Yeah.
Mr. Mayor, before you vote on that, may I comment?
Sure.
There are 13 Saturdays between now, I think 13, and May 1st. If the deadline is June 15th, why don't you make your approval of working on Saturday contingent on the deadline being moved up 13 days? Plus, the 13 days is a gift to the contractor. He knew ahead of time when he signed the contract what days he could work in town. If you're going to give him this gift, why don't you get some money back? $50,000 off the bottom line. So number 1, contingent on some cash back for the value of those 12 days of working. Number 2, move the deadline forward or back to June 2nd to compensate for the extra days.
Let's see how the vote goes. Ms. Taylor?
Commissioner Lyons,
No.
Commissioner Stanley,
No.
Commissioner White,
No.
Commissioner Orthwyne,
No.
Mayor Moore.
No. All right, Mr. Brandon.
Thank you.
Move on to the other issue, however. There was one raised by
Last
Mr. Graziano.
point, we had the question raised as to why not retain the FPL facilities in the alley. During the Storm Secure program that FPL launched, and they developed the proposal for undergrounding and the conversion of overhead facilities to underground facilities with the GA credits and those kind of things. Also the Florida Public Service Commission approved an additional requirement that all the distribution system facilities would be front lot facilities. have to be accessible to FPL's maintenance vehicles. The underground system going in here cannot by law be put in the rear alley.
I mean, I assume that's state law, I'm not sure what you mean by law.
The Florida Public Service Commission tariffs are considered to be the law in the state of Florida.
And this is a change or something that developed?
It was a change that happened with the approval of the GAF credits and the Storm Secure program after the 2004-2005 hurricanes.
Mark, comment?
I was talking with Mark Meyer, talking with Tony on the outside. He said that the original plan was to put the transformer in his front lawn. He did not give approval, and he told me outside that the transformer is going in the alley. So I don't know you can't have, some people have it in their front lawn, but some go in the back alley. So I'm confused. If Tony's correct and he did not give the easement and it's being put in the back alley, I'm not sure I get why it's not a uniform decision here.
Mr. Brown?
If this is the residence that I think it is, that the transformer was originally looked at putting it in his southwest property corner, but his property is on the corner, the alley is behind his house, and the alley butts right up against the street, and the transformer is setting just off the street right away at the very end of that alley, accessible to FPL vehicles.
It's on Lakeview, right?
Yeah, I think so.
Yeah, it's right off the
On
street.
the north side of the lot.
Right. And typically, FPL says that these transformers access points need to be within about 20 feet of the right of way because the trucks can still reach over and pick them up.
Other questions? Thank you, Mr. Brown. Let's move to the town manager report. We establishing oversight authority from the proceeds from local government infrastructure surtax.
Thank you, Mayor. There is a requirement in regards to the passage of the 1 cent surtax that all recipients must have an oversight committee. And the options, or the purpose, is to make sure or to give the public an assurance that the revenues being received, the tax revenues being received, will be expended upon road projects. And the options are, 1, we can form our own oversight committee, or 2, we can join with the Palm Beach County League of Cities as they are creating an oversight committee as an option of forming our own. Based on our workload and transitions and longevity, it is my recommendation that the town of Gulfstream join with or utilize the oversight committee of the Palm Beach County League of Cities.
I agree with that.
Certainly makes sense. We need a motion.
Yes. You're gonna bring back a resolution at the next meeting, correct?
Yes.
So you can just direct staff to, well, have a motion to approve that, and then bring back a resolution.
So there'd be a motion under County Ordinance number 216-032 that Gulfstream participate in the oversight committee being created by the Palm Beach League of Cities. Is there such a motion?
Go ahead. I'd like to make that motion.
Second?
Second.
Ms. Taylor?
Commissioner Lyons?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwein?
Yes.
Mayor Morgan?
Yes. ARPB, Architectural Review and Planning Board's meeting next is January 26th at 8:30 a.m. for anyone who wishes to attend. Finance Director report.
You've been provided a balance sheet and cash and budget report for the month ending December 31st, 2016.
Any questions? If not, we'll accept that as submitted. Chief Allen, police activity report.
I would request the activity report be accepted as submitted. Along with it, I'd like to just announce that the former Sergeant Hasley has been promoted to the position of Lieutenant Hasley. He will replace my previous position and fill those shoes. Lieutenant Hasley has been with the department for 24 years. 16 of the past 16 years he's been a road patrol sergeant. He has a wealth of knowledge and very loyal to our agency, and I think he'll do an outstanding job for me.
Excellent choice. Congratulations, Lieutenant. Any questions of the chief? If not, we'll accept that report as submitted. Let's move on to commission action. Items by mayor. One item that I would like to bring up is the renovation of Town Hall, the potential expansion of the Town Hall building. We've talked about it a few times. It was brought up at a public meeting in which we discussed future expenditures and improvements to the town. I believe some preliminary drawings were prepared by architect Mark Marsh, but I think we need to focus on it and move the project forward. Anyone who's spent any time at all in Town Hall realizes how small it is for the staff that we have. We have someone utilizing the library. Mr. Nazaro works out of the commission room, and we have file cabinets in the hallways everywhere. The building is too small and needs to be expanded. I have asked Mr. Thrasher to do some exploration on costs, if you have anything to report on the process that we might move forward with this and what costs might be expected.
Generally speaking, in regards to the cost of the building, it's just verbal from respected contractors. We're looking at high-end $300 per square foot. We're looking at expansion of 600 square foot, which would be a total of $180,000. So as reported in the earlier long-term planning meeting, we reported that we estimated to be $200,000. That figure remains the same. The next step would be for construction drawings to be created, and we then would turn it out for bid. I'm not sure exactly what that process would require, whether getting a few bids or whether it be an RFP, but when we get to that point, it would be determined with the assistance of attorneys. So at all that we should be looking at and for authorization at this point is the go-ahead for the development of construction drawings.
I'd like to approve that. It's been a much needed situation for a long time. We looked at it probably 10 years ago to add on because as things were progressing, we needed more space.
Well, staff was required to first accomplish the task of building fund balances.
Right.
In the general fund specifically, and it is my opinion that task has been accomplished and we now can fund from fund balance this small little project.
It's a much needed project.
It is.
Other comments, questions, Mr. Thrasher?
The only question I have is, generally, what would you do for the public too in terms of expanding? I'm not sure how you.
Well, we would be looking at creating a more symmetrical building. You stand on the north side of the building and look south, you'll see that there is a potential of a bump out on the west side of this building. So we would expand out 20 or 30 foot from the existing building, tie that roof structure and arrangement into the existing. And it would provide symmetry, so it's nothing out of the ordinary. And in addition to that, it's about as far as we can go without reconfiguring the driveways.
Thank you.
Those are the drawings Mark Marsh did quite a while ago, right?
They will have to be revised.
Right.
We had a certain intent at that time. We will get more specific and for utilization of existing help.
The other thing for the public too, which a lot of people are down on office space and things like that, is we have to have a more bona fide server room. So we spent 50 minutes of this meeting talking about town functions, public records requests, the good work Trey's done, the staff. You have to have the proper equipment to keep running a town, and so part of the redesign will be, and the new plans will be the proper fans, ventilation. We've got some pretty big racks in there. They're only going to get bigger, as you can see with our portal and everything. We don't like paper for public records and so on and so forth, so that'll only get bigger, and you've got to cool that stuff.
The building was built 32 years ago, and the times have changed.
Should we do this by consensus, or should there be a motion?
I think you should have a motion directing the manager to move forward with the project.
Is there a motion to move forward, directing the town manager to move forward?
I'd like to make a motion to direct the town manager to move forward with working drawings, updating the drawings we've had from a long time ago to working drawings.
Is there a
Construction
second?
drawings.
Construction.
Is there a second?
Second.
Mr. O'Hara?
Thank you, Mr. Mayor. This is a Spanish-y style building. I think what I'm hearing, because I don't hear everything that's said, but I think what I'm hearing is you're planning on amending or putting appendages on this building. And what I'd like to propose you consider is that you've got a big chunk of land here. There's gas tanks there. The police drive by 3 gas stations every day on their patrols. They don't have to buy their gas here. Why don't you build a municipal complex right behind Town Hall that includes the police station? While that construction is going on, there's no disruption to what's going on in here. And then to pay for it, when it's completed, you sell the police station property for maybe $1 million to put towards that debt, and then people just pick up their stuff one day and move into the new building. Very little disruption to staff, and you've got a brand new building that could be in the Bermuda style that the town likes so much, so it's conducive to the core area, its style. And it seems to be the least disruption to the staff, and I bet you by the time you're done with all the patchwork on here, every time you have to do it, it'll probably cost more than just building a new building from the ground up in the style that you would all find most conducive to the town. That's all, thank you.
Thank you. If no other comments, Ms. Taylor?
Commissioner Lyons?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwein?
Yes.
Mayor Morgan?
Yes. Move on, there is a resolution number 17-01 for our consideration. Ms. Taylor?
A resolution of the Town Commission of the Town of Gulfstream, Palm Beach County, Florida, designating the supervisor of elections, the town clerk, and the administrative assistant to the town clerk as a canvassing board to be in attendance for the testing of the computer electronic systems, tabulating equipment, to be used for the general election scheduled for March 14, 2017, and to canvass returns of such election, including the absentee ballots, assigning supervisor of elections to handle the absentee ballots, providing for repeal of prior resolutions in conflict herewith, and providing an effective date presented for adoption this 13th day of January 2017.
Resolution number 17-01 has been read for our adoption. Is there a motion to adopt?
Motion to approve.
Second.
Ms. Taylor?
Commissioner Lyons?
Yes.
Commissioner Stanley?
Yes.
Commissioner White?
Yes.
Commissioner Orthwein?
Yes.
Mayor Morgan?
Yes. Any other comments from the commissioners? If not, means adjourned.
Can I just
Got
ask
one.
something quick? When I was reading through the surtax, the ordinance on the surtax, and a section there for the uses for the 1 penny money, and they talk about reconstruct, and could that be used could that money be used for our water mains in the future? Could we consider the water mains, sewer systems, or natural gas lines in that for future ideas? I mean, the sewer systems and natural gas lines, I know, have been discussed in Plaza Soleil.
In my opinion, the answer is no. I wouldn't say that that's 100% accurate. Perhaps Mr. Randolph knows, but in discussions I had, and specifically for Gulfstream, there are capital expenditures earmarked for roads.
But I know for this year, but like in future
No.
years.
For the surtax.
For the search.
That's correct.
Okay, because I think I read in there for water infrastructures.
What bears investigation?
Sure.
I can look into it, sure. We have reported to the county as to what our capital projects would be. I have, based on previous discussions and meetings with the commission. Whether or not I can change that, I do not know, but I can. What specifically are you wanting to do? That might help you.
Well, Plaza Soleil talks from time to time about hooking up to like sewer lines, instead of using septic.
We're not anywhere near that kind of money in our revenue from surtax.
Mhm.
We'll get $45,000 to $50,000 a year. At max, maybe 15, 20 years would be $1 million, $1.5 million. The cost for installation of sewers for Plaza Soleil and over here, we have completed a sewer study in years past. It's been presented to the commission, and the volume of cost was just almost scary. So that could not be accomplished with that money. And then in regards to Plaza Soleil, they wouldn't be the benefactor of the entire amount of funds. And previously, there has been a great deal of conversation and comments in commission meetings from Plaza Soleil members and residents that wanted their roads fixed up. And so when you look at the flow of money, 45 to 50 per year, you're very limited as to what you can accomplish.
Well, I understand the roads are the first priority, and that's the first priority. I was just looking into the future and seeing if in the future, because this surtax is good for 10 years.
Or until the time that they
Until it
need
reaches
2.8.
$2,700,000.
Yeah, so it's a good idea, but it's not going to be accomplished with this surtax for our town.
So based on the limited revenue that we might see from it, you
Right.
made proposals to the county, or to the.
Well, I do that from a perspective of what we have done in our history with viable budgets, that we've never budgeted more than $50,000 to $100,000 for roads. This is the first year in this current budget that we have more than that. I think we have 220,000. So that seemed to be the logical and supportive project that Gulfstream has, and it was reported as such, and it is needed. So my estimates for road overlay in the core was over $1.5 million. So we will have to supplement everything that we do, that we receive from the surtax. And then that estimate did not include Plaza Soleil. We have had our roads surveyed, and they believe, this particular individual believes that those roads in Plaza Soleil can wait until the following fiscal year. So know what to say. Other than I appreciate the process and the project and the need for it or the desire for it, but there would have to be other types of funding that the commission decided upon in order to accomplish that task.
Okay. Any other questions? Comments? Nothing for the good of the order? Meeting's adjourned.
Thank you, Mayor.
Remain to sign the resolution.
Yes.